Remarkable things have happened in the world of copyright this week. What we're going to talk about today is the subpoena of internet subscribers through the DMCA process. A law firm out of Hawaii, you may be familiar with the Kerry Culpepper law firm, Culpepper IP, I believe it is, had requested a subpoena through the DMCA 512H process. One identity, one person objected, and the court took it from there. So now a panel from the Ninth Circuit Court of Appeals has issued a precedential or for publication decision. That's what for publication means. The panel addressed as an issue of first impression whether the DMCA allows a 512H subpoena to issue to a 512A service provider when the service provider plays the role of a conduit for the communications of others as opposed to a service provider who stores or provides a link to infringing material. You have service providers like Cox. I say like Cox. Cox is the service provider currently at the Supreme Court right now because they're getting sued by, I don't know if it's Kerry Culpepper, but similar plaintiffs, similarly situated plaintiffs who want to enforce copyright but are unsatisfied with being able to enforce copyright law against individual infringers, as opposed to visiting these infringement allegations directly against Cox themselves, who has much deeper pockets and will be able to pay a monetary recovery a lot more easily without having to go through individual lawsuits, which is what we're back to. After this Ninth Circuit decision, plaintiffs in the future will likely have to file individual lawsuits against infringers by IP address, and that's the Strike 3 Holdings way. That's the sort of thing I do. I defend people from those things. So I imagine I'll be seeing more of Kerry Culpepper in the future. Okay, so here's the opinion. Let's go through it. Capstone Studios, a copyright holder, successfully petitioned a district court clerk to issue a subpoena pursuant to 512H of the Digital Millennium Copyright Act to Cox, an internet service provider. Capstone sought to obtain the identities of 29 Cox subscribers whose IP addresses appeared to be sharing pirated copies of Capstone's movie Fall via a peer-to-peer file sharing protocol called BitTorrent. One of Cox's subscribers objected to the subpoena. Upon review, the district court concluded that Cox qualified for one of Section 512's 4 safe harbors. Subsection A, because Cox merely provided its users with an internet connection and played no other role in the infringement. The district court concluded that a 512H subpoena cannot issue to a 512A service provider as a matter of law because Cox acted only as a 512A service provider with respect to the alleged infringement. The court deemed Capstone's subpoena invalid. The district court quashed the subpoena. Capstone appeals. We affirm the district court's order. This case concerns 512H, a provision of the DMCA that establishes an expedited subpoena process through which a copyright holder can obtain the identities of online infringers. What's the big deal? You can't get a subpoena this early in the process. You can't uncover an internet user's identity by merely filing a motion with a court. You must file a properly pled complaint under Federal Rule of Civil Procedure 8. It must survive a motion to dismiss, and you must get into the discovery process after Rule 26 disclosures and a Rule 16 conference and a scheduling order and everything. You finally get into the discovery process, and now you can uncover the identity. That was the old way. That's the normal way. The new way is you file the properly pled complaint and then also file a motion for what's called an expedited subpoena, literally an out-of-order subpoena. That's what we're talking about here. We can skip the complaint if we use the 512H process. So if you have information, copyright, media, a movie, music, whatever, existing on a web server or cloud storage drive, that you can still issue a 512H subpoena for that person's identity. That's what we're talking about. You're skipping the complaint process. You're skipping a judge's scrutiny. The clerk simply issues the subpoena in this case. So it's a really easy way to get a subpoena. It's a cheap way to get a subpoena. Cheap as in money and cheap as in time. The Digital Millennium Copyright Act establishes an expedited subpoena process through which a copyright holder can obtain the identities of online infringers. The clerk of any United States District Court can issue a subpoena to a service provider on behalf of a copyright holder. Service providers are entities that maintain websites, deliver network access, or host content. If a copyright holder's petition for a 512H subpoena meets the statutory requirements, the clerk shall expeditiously issue this proposed subpoena without oversight from a judge. As the Eighth Circuit explained in re Charter Communications subpoena enforcement matter in the Eighth Circuit 2005 case, without the DMCA's expedited subpoena process, a copyright holder seeking to learn the identity of infringers sharing copyright-protected content on the internet would have to file an infringement action against individual users suspected of infringement, naming each as a John Doe, and then move the court for leave to conduct early discovery. In enacting 512, Congress struck a compromise between copyright holders and service providers. Section 512 preserves strong incentives for service providers and owners to cooperate to detect and deal with copyright infringements that take place in the digital networked environment. The safe harbors that Congress included limit service providers' liability for their users' infringement in exchange for their cooperation in removing infringing content from the internet. Most of the safe harbors require service providers to remove or disable access to infringing material upon notification from the copyright holder. This is referred to as the notice and takedown process. The statute's 4 primary safe harbors protect service providers depending on the technical role they played in the alleged infringement. 512A limits the liability of service providers when they did nothing more than transmit communications of infringing material. B limits the liability of service providers for system caching, that is, when they provide intermediate or temporary storage of material on networks or systems. C limits the liability of service providers for material that resides on their systems or networks at the directions of users. D is for information location tools, and I think we said E was for nonprofit organizations. The alleged infringement at issue here took place via BitTorrent, a peer-to-peer network protocol, so-called because users' computers communicate directly with each other rather than through centralized servers. See Grokster. The BitTorrent protocol responds to a user's request for a file by connecting to the internet and identifying peers. Other users who have requested the same file or part of the same file and have it stored on their devices. Peers are identified by their internet protocol addresses. A user may obtain the requested file from multiple peers. One peer might complete one portion of a request and send one part, and additional peers may supply the remaining pieces. Eventually, BitTorrent ensures that the user obtains the completed file. Without the need for a centralized server, P2P networks can circumvent storage costs, exchange file fasters, and avoid risks that a malfunction on a server will disable the network. But a lack of a centralized server also makes it difficult to monitor, to regulate, remove content, which makes it difficult to police copyright infringement. Copyright holders monitor torrent trackers. A torrent tracker is software that assists in the communication between peers. Trackers monitor which peers have which pieces of the files and identify who needs which pieces. Any peer can contact a tracker at any time to obtain a list of peers who are sharing a file. Thus, by monitoring trackers, copyright holders can identify peers, collect IP addresses, discover their identities, and bring infringement claims against them. Appellant, Capstone Studios, owns the copyright to the movie Fall 2022. Capstone alleges that Fall has been subject to massive internet piracy through the BitTorrent protocol. Capstone specifically identified 29 IP addresses that it suspected of sharing Fall through BitTorrent through Cox, the internet service provider. Capstone petitioned the district court clerk for a subpoena under 512H. The clerk issued the subpoena April 13th, 2023. Cox gave notice to its affected subscribers, informing them of the subpoena and requesting that they notify the court if they have any objection to Cox responding. One affected subscriber, John Doe, wrote a letter informing the district court he did not download Fall. John Doe stated that upon receipt of the subpoena, he realized that he had forgotten to add a password to his Wi-Fi router, leaving his network open for anyone to use. John Doe asked the court to quash the subpoena and objected to the release of his identity. No other subscriber objected. A magistrate judge construed John Doe's letter as a motion to quash and directed Capstone to respond. Capstone did, and it argued that John Doe did not assert a legal basis for quashing the subpoena or identify an undue burden or expense that would result from complying with it. August 31st, the magistrate judge issued findings and recommendations that the subpoena was invalid and should be quashed. Although not raised by John Doe or Capstone, the magistrate judge concluded that the subpoena was invalid because Cox's role in disseminating the copyrighted material was confined to providing the internet connection, which qualifies for the safe harbor under 512A. Relying on the text of the statute and case law from other circuits, the magistrate judge concluded that 512A service providers cannot be subject to a 512H subpoena as a matter of law. Capstone objected, and then Cox appeared and filed a response for the first time. The district court adopted the findings and recommendations over Capstone's objections. Capstone filed a motion for reconsideration, which was denied. Capstone now appeals. The validity of Capstone's subpoena turns on two issues. First, as a matter of law, whether the DMCA allows a 512H subpoena to issue to a 512A service provider, and second, whether Cox acted only as a 512A service provider with respect to the infringement at issue here. We have not yet had an occasion to address this issue. To answer, we need to look no further than the text of the DMCA. Subsection 512A states that a service provider shall not be liable for infringement of copyright by reason of the provider's transmitting, routing, or providing connections for material through a system or network controlled or operated by the service provider. They must also meet additional requirements. The transmission must have been initiated by a person other than the provider, and the provider can't maintain a copy longer than necessary for the transmission. 512A is materially different from the other safe harbors. They all contain notice and takedown provisions that condition qualifications for the safe harbor, except for A. Upon notification of claimed infringement, a service provider must respond expeditiously to disable access to the material claimed to be infringing. This provision is absent from 512A. The reason for this omission is clear from the text of the safe harbors and the different functions Congress sought to exempt from liability. B and C limit liability for service providers who provide intermediate and temporary storage of material and storage at the direction of a user. If a service provider qualifies for B or C because infringing material is stored or resides on their system or network, the service provider has the ability to remove the material from its system or network, or disable access to it upon receipt of a notice of infringement. Similarly, D limits liability for providers who refer or link users to an online location. A service provider who qualifies for D can disable access to the infringing material by disabling its directory or hyperlink. A limits liability for service providers who transmit communications. Congress intended to limit the safe harbor to service providers who play the role of a conduit for the communications of others, as opposed to service providers who store infringing material. Unlike B through D, A service providers furnish only the connection through which infringers exchange content. By definition, there is no infringing material that resides on a 512A service provider's system or network, nor is there a link or a directory. The service provider cannot participate in the notice and takedown process because there is nothing for the service provider to take down. With this understanding of 512A and the notice and takedown process, we turn to the text of the subpoena provision. A copyright holder's request for a 512H subpoena must include a copy of a notification described in C3A, the DMCA takedown provision, which informs the service provider of the alleged infringing activity. The notification in C3A is the same for B through D service providers that must respond expeditiously and disable access. The notification must satisfy 6 requirements, including identification of the material that is claimed to be infringing. The C3A notification requirement presents a problem for a 512A service provider because a 512A service provider merely furnishes an internet connection to its subscribers. Such a provider cannot remove or disable access. The 512H subpoena provision is inextricably intertwined with the C3A notification, cross-referencing it 3 times. 1. The request for the subpoena must contain a copy of the notification. The clerk must issue the subpoena if the notification satisfies the provisions of C3A, and the service provider shall expeditiously respond. The statutory text confirms that a 512A service provider is not a contemplated recipient of a proper C3A notification. For these reasons, the DMCA does not permit a 512H subpoena to issue to a 512A provider. 2 other circuits have reached the same conclusions. We're going to call them the Verizon and Charter cases. In Verizon, the RIAA served 2 subpoenas on Verizon to discover the names of 2 subscribers who appeared to be trading in MP3 files of copyrighted music via peer-to-peer file sharing programs, including Kazaa. The parties did not dispute that Verizon acted as a 512A provider with respect to the infringement, and Verizon argued that 512H does not authorize the issuance of such a subpoena. The D.C. Circuit concluded, based on the text of 512H and the overall structure of the law, that a subpoena may be issued only to an ISP engaged in storing on its servers material that is infringing. Roughly a year later, the 8th Circuit agreed. In Charter, the RIAA again requested that a district court clerk issue a subpoena to Charter, an ISP, to produce the names, etc., of 200 Charter subscribers. The 8th Circuit observed that the notice and takedown provision did not apply to 512A, and that the remove or disable access requirement prevented 512A providers from receiving a proper C3A notice. Charter adopted the reasoning in Verizon. Capstone argues that despite the lack of a statutory provision, a 512H subpoena can issue to a 512A provider because a 512A provider can disable access to the infringing material. In support of this argument, Capstone provided a declaration from its expert witness, David Cox, no coincidence or irony there, the owner of an information technology network consulting service. The declaration explained 2 different methods an ISP could use to disable access to infringing content short of terminating its user's internet connection: destination null routing and port blocking. Capstone's expert explained that destination null routing prevents users from reaching specific destination IP addresses. Because an IP address can be associated with a computer as well as a website, an ISP can null route any user that tries to reach a website or computer hosting the infringing material. Instead of reaching that particular IP address, the user is routed away or the transmission is dropped. In the case of peer-to-peer networking, Capstone's experts stated that an ISP could null route the traffic of any subscriber that tries to reach the IP address that contains the infringing material. Well, okay, you have a problem there. IP addresses serve multiple users. Sure, you could have one IP address be one person, but that's probably more rare than anything else. So it's also true that IP addresses serve multiple services. So blocking access to infringing material by blocking an IP address means you're going to block an entire swath of internet access, not just the infringing material. Yeah, you'll get the infringing material, but you'll get everything else too. And you probably don't know what you got because you don't have any idea what's on the, what else the IP address serves, because what's not on BitTorrent is not publicly disclosed like that. Very few services publicly disclose, hey, everybody, I'm a open web server over here, is different than hey, I'm a secure service over here, and it's not going to advertise itself. Destination null routing does still allow the user to access other IP addresses. Capstone's expert also explained port blocking. Ports are virtual points where network connections start and end. Ports are numbered and standardized across all network-connected devices and allow computers to easily differentiate between different kinds of traffic. It's kind of like having different doors on a building. The IP address is the building, the port numbers are the doors. Many ports are associated with a specific processor service. Email goes through port 25. Well, yeah, but not anymore. Unsecured web traffic goes through port 80, secured web traffic through port 443, remote desktop through 3389, etc. Ports are typically open when they can transmit and receive data. Port blocking is a process of closing the port for a particular user. BitTorrent commonly uses traffic on ports 6882 through 6889, so the ISP could just block that. The DMCA, says the court, does not define the phrase disable access to, but in Verizon, the case, the DC Circuit considered whether an ISP can disable access to infringing material by terminating the offending subscriber's internet account. The DC Circuit rejected the RIAA's argument that disabling users' access to the internet is a way of disabling access to the infringing material, because termination of the customer's accounts is a different remedy already set forth in a different provision of the law. The DC Circuit concluded that Congress considered disabling an individual's access to infringing material and disabling access to the internet to be different remedies. Neither the Verizon nor Charter cases specifically grappled with destination null routing or port blocking, measures that do not go as far as terminating a subscriber's account, but in our view, the Ninth Circuit's view, these measures do not go far enough because they do not disable access to infringing material within the meaning of 512. As the district court recognized, destination null routing and port blocking cannot disable access within the meaning of C3A because an ISP can use these methods only to prevent its own subscribers and not other ISPs' subscribers from reaching destination IP addresses containing infringing materials or using ports that commonly route to infringing material. In other words, an IP address cannot disable access to infringing material via port blocking and destination null routing. It can only disable its own subscribers' access to infringing material. Capstone points to nothing in the text or legislative history of 512 suggesting that Congress contemplated such a piecemeal application of the notice and takedown procedure. Because a 512A service provider cannot remove or disable access to infringing content, it cannot receive a valid C3A notification, which is a prerequisite for a 512H subpoena. Therefore, it cannot receive a 512H subpoena. Capstone makes several textual arguments to the contrary. We can skip because the argument borders upon the silly, because it does not resolve the main conflict. A 512A service provider cannot remove or disable access to infringing material, regardless of how you define whether you can send them a notice or not. They still can't remove access to the material. Below and on appeal, the parties agreed that Cox did nothing more than assign IP addresses and provide the internet connection to its 29 subscribers. The parties have only ever disputed whether those services qualify as transmission services in 512A or information location tool services in 512D. The court clearly understood, and Capstone did not dispute, that the infringement took place via peer-to-peer networking, and the extent of an ISP's technical involvement in peer-to-peer networking is thus limited. The district court did not need any additional evidence to find that Cox acted only as a 512A service provider. Because Cox's role in the alleged infringement was limited to that of an ISP, and because a 512H subpoena cannot issue to an ISP under those circumstances, Capstone's subpoena was invalid and the district court did not abuse its discretion when it quashed it. We affirm the district court's order quashing the subpoena and denying Capstone's motion for reconsideration affirmed. Boom. As it should be, it makes perfect sense that you can't subpoena Verizon for the identity of its users just because its users are accused of infringement using this expedited process, using this bypass the court, kind of bypass due process. So if there is infringing material on a storage system of some kind, whether that be served by a web server or hosted by a cloud storage drive, those are still fair game for 512H subpoenas. But just because you see infringement on a BitTorrent peer-to-peer file-sharing network, just because you can record the IP addresses does not mean that you can get the identities through the 512H process by sending subpoenas to the internet service providers. Yay! Because it would have been the Wild West. It already is kind of the Wild West, but it really would have been a free-for-all if attorneys like and including Kerry Culpepper would be able to get subpoenas for people's identities en masse. I cannot overstate how devastating these lawsuits are for people. People think that they're committing a light crime or a light offense, a speeding ticket, or some kind of, oh, well, if I get caught, it'll be $50 offense or something like that. And instead, it is $750 per movie, per title, per book, per music, whatever, per song. So $750 per title is not what people expect. And it's more than that because it includes attorney's fees, and it includes a multiplier for willfulness when proven, and it includes the stress and time and burden of a lawsuit. So getting one of these notices in the mail is a big deal, and therefore the plaintiff should have to handle it like it's a big deal as well. They have to file a lawsuit against an individual John Doe, ask the court for permission to unmask the John Doe via a subpoena, and then that lawsuit, with the judge's oversight, even though there are many of these lawsuits and the judges seem to rubber stamp the subpoenas, they still have to put skin in the game. The plaintiff has to file a lawsuit and put their money ante up. They have to ante up before they are allowed to play the game. And the 512H subpoena process allows them to ante up without anteing up in a way when you consider these circumstances. Anyway, let me know what you think in the comments below. I'll see you in the videos that drop. I love you all. I'm Leonard French, your favorite copyright attorney. Have a great week. Let's see. Can I see you now?